Hello, I'm Todd Smith, and this is your appellate tip of the week. This week's tip is how to hire an appellate specialist to help with a critical trial court hearing. Why might you want to bring in an appellate lawyer to help you with a matter that's going to be heard by a trial court? The circumstances to which this idea really applies are those in which you've got a potentially case dispositive motion. A number of those come to mind, such as motions for summary judgment, special appearances, Rule 91A motions, motions for temporary injunction, which can be effectively dispositive, pleas of the jurisdiction. And also, we often see motions to dismiss under the Texas Citizens Participation Act, which are very frequently appealed. Each one of those motions involves a particular skill set that requires the lawyer to be able to effectively present legal argument to the trial judge. And that's written legal argument and also potentially oral legal argument to the judge at the hearing. And so there's a procedural device. It's not necessarily a formal device, but there is a procedural device available that would allow an appellate lawyer to come in at the behest of a trial lawyer and apply that appellate lawyer's skill set to these issues in a way that could potentially be persuasive to the trial court and really put the case's best foot forward and assist the trial lawyer in getting over a hurdle that some trial lawyers don't feel comfortable dealing with, these kinds of dispositive motions. And so you hear about this described sometimes as a limited scope representation. Most often, where you hear that term is when a pro se litigant is looking for help with a specific issue pending in front of a court. They don't have a lawyer, and they need a lawyer to come in and help on some issue that involves skills beyond what the average layperson could take care of. But this is the same concept. It's essentially a limited scope representation where the trial lawyer retains an appellate lawyer to come in, I like to say parachute in, handle a very narrow sliver of the case, and then you're able as the appellate lawyer to conclude your involvement at that point, or really it's between the trial lawyer and the appellate lawyer about what the ongoing role would be. But what I'm talking about in this video is literally a trial lawyer wanting help with let's say a summary judgment motion, the appellate lawyer coming in. You can file a notice of limited representation, particularly in Travis County, where local rule 20.2 specifically provides for this. And then when the motion is done and the hearing is done, you can pretty much walk away without any ongoing responsibility for the case. Again, that's specific to Travis County, which has a rule that addresses this. So the advantage is you get the benefit of the expertise on legal issues that an appellate specialist brings without bringing that person into the case on an ongoing basis, and therefore keeping the fees down for the client, increasing the benefit to the client, allowing the trial lawyer to continue doing what they do best, which is handle the witnesses, handle experts, taking depositions, dealing with discovery issues, things that appellate lawyers don't necessarily do very well. And then in that way, the two types of practices can blend really well. I've done this a number of times in my own practice. I think the lawyers that I've done it with have felt like it was beneficial. And I think other trial lawyers really ought to consider doing this too for the kinds of cases that warrant it economically, when the complexity of the issue is sufficient, and if you're facing or think you can bring a potentially dispositive motion that really might put an end to the case, depending on your view of it, either prematurely or early on and effectively for your client. That's it for this week's tip. We'll see you next time.